Good afternoon and welcome. My name is Julia McCue.
Thank you.
Sorry. And I'm a member of the library board. Can you all hear?
No.
No? Okay.
Closer to your mouth.
Okay, right to my mouth. Okay. The McCue Lecture is an annual event and is supported by a gift in honor of Gertrude and Alan McCue, whose Claremont Hotel lecture series existed for about 40 years. The library is grateful for the support of the town of Southwest Harbor and also for the generosity of year-round and seasonal residents as well as visitors who provide us with 90% of our operating budget. This year, the lecture is being held as part of the library's 130th anniversary week. There are many special anniversary events, and they are listed on this card, which you can get there and also at the circulation desk. And they include a talk by Maine author Richard Russo, cookie decorating tomorrow for kids, and other good events. The library is a communal space and open to all. It holds talks and lectures all year round. One talk that did not make it to this card, which lists summer events, also available at the circulation desk, is a conversation between Korean American authors Rosa Kwon Easton and Hae-Soon Song, whose new books, one a memoir and one a novel, concern the immigrant experience. And that should be a very good conversation between two women who came to publishing late in life and who are approaching the same experience from different experience. They are approaching the same issue from different ways. So this is your library. If you don't have a library card, you should get one, and or subscribe to our e-newsletter, which will let you know about talks all year round, many of which are available on Zoom, which this one is. So now I'm going to turn it over to Bill McCue to introduce Lincoln Caplan.
Thank you very much, Julia. Have I got this the right distance from my chin? Good. Welcome to all. And to be honest with you, I was not fully aware that I'd be using this microphone. So let's see if I can both hold a microphone in one hand and read a bit in the other with my other hand and hold the paper. In any event, good afternoon. So glad that you've all attended this lecture, and it will be, I'm sure, a very interesting one. 50 or so years ago, the epigram, "All politics is local," usually attributed to former House Speaker Thomas P. Tip O'Neill of Massachusetts, expressed the prevailing understanding of the bedrock nature of American politics. Today, there's a good argument to be made that the epigram should be updated to "All politics is constitutional." The critical political issues of the moment, including such matters as the president's authority to attack foreign countries without benefit of a congressional declaration of war, the right of all persons born in the United States to citizenship, and the efforts of the executive branch to defund and gut certain government agencies that were created by Congress, are all ultimately constitutional questions. And when it comes to constitutional questions, all roads lead to the US Supreme Court. Which brings me to our distinguished speaker this afternoon, Lincoln Caplan, to my right. I'm just delighted and grateful that Link accepted our invitation to share his deep knowledge of the Supreme Court in this forum. By virtue of his legal education, his deep interest in and extensive writings about the Supreme Court, and his many years of experience with leading political news journals and scholarly journals, Mr. Caplan is uniquely qualified to examine whether, in his words, the Supreme Court has too much power or not enough. Lincoln Caplan has had a 50-year career deeply focused on our country's legal and political issues. That career began with his coverage for the New Republic of the dramatic 1974 case of the United States versus Nixon. Most of you will recall how that episode came out. Link's truly remarkable CV can be found at http english.yale.edu. I commend it to your reading, but please not now. Here are a few of the highlights. Link is the author of 6 books about legal matters, including American Justice 2016, The Political Supreme Court, and The 10th Justice, the Solicitor General, and the Rule of Law. Mr. Caplan has reported on the Supreme Court and written about it for the New Republic, the New Yorker, the New York Times, and the American Scholar. He has been a member of the editorial board of the New York Times and is the founder and president of Legal Affairs magazine. I could go on, but it is Lincoln Caplan you came to hear, not me. Please join me in welcoming Lincoln Caplan to the best little library in Maine.
I don't know if you are, I think I saw one.
Won't you make sure I get it right? Now am I on?
Okay.
How about now? Fine. Thanks so much, Bill. It's a tribute to the magnetism of the McCue lecture and of this library that there's such a wonderful turnout here for such a serious topic. It's an honor for me to give this lecture that Bill's parents established and that Bill and his sister and Julia have continued to support along with the town of Southwest Harbor. The McCues were great owners of the Claremont Hotel, and they were first-rate citizens of Southwest Harbor. With the library, they have continued a democratic tradition that I'll try to contribute something to tonight. One of my favorite poems is by Wallace Stevens, and it goes like this at the beginning. The house was quiet and the world was calm, and the reader became the book. All of you who are patrons of this library know what Wallace Stevens meant, and anyone who had the pleasure of reading anything on the porch of the McCue's Claremont Hotel knew how special the Claremont was in providing that kind of setting. In the summer of 1976, I took the Massachusetts bar exam, and I then lucked into 10 days of sailing on Penobscot Bay with some friends on a beautiful 42-foot yawl. One day we were sailing past what turned out to be the Claremont on Somme Sound, and I was struck by the hotel, but I couldn't quite remember its name. I can't remember what I was responsible for doing on the boat, but that seemed important. And a couple of weeks later, my wife and I arrived in Bar Harbor and went to a tourist information booth. And I described this marvelous yellow hotel with an emerald green lawn stretching down to the Sound, and asked if by chance the woman knew the name. And she said, "Oh, you must mean the Claremont." And she called the Claremont, and they had a room for my wife and me. And the person on the desk apologized that the dining hall had closed, but would it be all right if they made for us a couple of peanut butter and jelly sandwiches when we arrived, and gave us some cookies for dessert? And I said, "Yes, please." That was 49 years ago, and we've had many visits back to the Claremont and to Southwest Harbor since, and there is no more beautiful or restorative place to read and be than Southwest Harbor and this wonderful library. So now the Supreme Court. I'm going to talk about this important institution from the perspective of a journalist. As Bill said, I've had the privilege of reporting about the court for the New Yorker and the New York Times, and from Yale, where I have taught for the last 27 years off and on. I've continued to do journalism about the court. 10 years of my career were fully focused on the court for one institution or another. And as Bill mentioned, if you count from my first assignment to my most recent, it's been 50 years. If I were a professor of constitutional law or a political scientist, I would offer you an argument tonight. And I would try to back it up with theory, but I'm a journalist. So I'm going to tell a story, or try to, a story of ideas. And I'm going to tell a story in three parts. The first is about law and history, and really about journalism in the court. The second part is about law and political science, and really about the court and law and politics today. And the third part is about law and sociology, and really about legitimacy, a lawyer's word for trustworthiness. Along the way, since we're in a library, I'm going to refer to a few books that I greatly admire about the Supreme Court and that are relevant to what we're focusing on tonight. So the first part, it's about a great journalist. Some of you likely read Anthony Lewis. He was a journalist for the New York Times for 50 years, and he died in 2013, 2 days short of his 86th birthday. I could talk for the next 45 minutes about Mr. Lewis, but the part of his career I want to focus on is that he invented the way journalism covered the modern Supreme Court. Before he came along, the Times and every other elite outlet covered the court pretty much the way that covered baseball. They gave a box score in the sense of who won and who lost. They included a few interesting facts, and they devoted very little space to the court. Lewis instead covered it with a sense of history as an institution in a conversation with itself, how it understood and applied the Constitution and other forms of law, and what its reasoning was in law, and which reasons mattered most to the outcome in a particular case. In the 1950s, a justice named Felix Frankfurter called the publisher of the New York Times, and he said, "You need to cover the Supreme Court at least as well as you covered the World Series, and you do not." And the publisher called the head of the Washington Bureau, a man named James Reston, and Reston looked around the newsroom and he spotted Tony Lewis. Reston called Lewis a scholar who could run. And what he meant by that was Lewis was smart enough to understand the law and to translate it into English, but he was also a skillful reporter. The year before, when he was 28, he had won a Pulitzer Prize, the highest award for journalists, for a remarkable piece of investigative journalism. And so Reston sent Lewis to Harvard Law School for 1 year in 1956 to 1957, studying constitutional law and other subjects to reinvent court coverage in a form of translation that non-lawyers could understand. Like his hero, Justice Louis Brandeis, Lewis believed that the most important public office was that of citizen, and that's who he wanted to report and write for. In each case he wrote about, Lewis answered very basic questions. Who were the parties? What was their disagreement? What law was at stake? And how did the parties view that law differently? And importantly, how did their views differ about its application to the facts? He was especially interested in consequences. What happened to the law, the parties in the case, and the country because of the court's decision one way or the another. History mattered as a shaper of law to Lewis, and he was intently interested in reporting about the court with attention to the kinds of things that historians paid attention to. Lewis was a scholar. That year at Harvard, he wrote a law review article disputing a significant Supreme Court case. In 1946, the court had decided that it needed to stay out of what it called the political thicket. It should not decide whether states had fairly or unfairly drawn the lines for legislative districts or allocated population in those districts. It should leave to the states whether, for example, as occurred in Tennessee, which was the source of that particular case, it should leave to the states imbalances like ones in Tennessee, where urban districts had 18 times as many people as they did in rural districts, which meant that the rural districts were 18 times as influential voter for voter. Felix Frankfurter, the justice responsible for Lewis going to Harvard Law School, wrote the opinion that Lewis criticized in his law review article. Lewis was very respectful of Justice Frankfurter. He wrote a beautiful profile of Justice Frankfurter in the New York Times Magazine, which reported, among other things, that Justice Frankfurter expressed his delight about being a justice by whistling Stars and Stripes Forever in the halls of the Supreme Court. But Lewis took Frankfurter on head on, and he urged in his law review article, and I'm quoting, "Supreme Court action is the only effective means to correct the growing evil in inequitably apportioned legislative districts." In 1962, when the court decided that question, Lewis was in his 5th year covering the court. And when the court did what he advised in that law review article, not because of that, but consistent with it, he said the Supreme Court held today that the distribution of seats in state legislatures was subject to the constitutional scrutiny of the federal courts. The historic decision was a sharp departure from the court's traditional reluctance to get into questions of fairness in legislative districting. Lewis did not mention it in the New York Times, but in footnote 27 of the court's opinion in that case, it cited Lewis's law review article as authority. And he won a second Pulitzer Prize for his coverage of that issue and how the court eventually decided that each legislative district should be equal in population. So each voter should have the equivalent of the same vote. And within a few years, almost every state in the country, 46 states, had reapportioned their legislative districts. And by wide acclaim of conservatives as well as liberals, they had renewed that portion of democratic life. That perspective is valuable for us as a reference point today. In 1964, in a classic book that Lewis wrote called Gideon's Trumpet, which is still in print, here's what Lewis wrote about the court. "The Supreme Court of the United States is different from all other courts, past and present. It decides fundamental social and political questions that would never be put to judges in other countries. The boundaries between church and state, the relations between white and black races, the powers of the national legislature and executive. Its public image seems sometimes to be less that of a court than of an extraordinarily powerful demigod sitting on a remote throne and letting loose constitutional thunderbolts whenever it sees a wrong crying for correction." But he went on, "The Supreme Court is not a demigod, nor even a roving inspector general of the conscience. It is a court, and for all its power, it must operate in significant respects like as courts have always operated. It cannot, like a legislature or governor or president, initiate measures to cure the ills it perceives. It is, as Justice Robert H. Jackson said, a substantially passive instrument to be moved only by the initiatives of litigants. In short, the court must sit and wait for issues to be presented in lawsuits." Lewis wrote about the court with great respect. He was a liberal and the court's best known decisions then were liberal, Brown versus Board of Education, ending segregation in public schools, Miranda v. Arizona, requiring the police to inform people being arrested of their rights under the Constitution. I could go on with this list. So it's easy to think, of course, Anthony Lewis respected the court. He agreed with it. They were doing what he hoped they would do, but that was not his reason for his respect for the court. He especially respected the court in how it managed its awesome power with patience and, critically, his word, with self-restraint. He was mindful of the conflicting views of law among the conservatives and liberals on the court, but he admired that the differences then were not partisan, that all the justices worked hard to explain their views and their differences. He especially respected that the court decided what it needed to, and in the American tradition of federalism, as Lewis learned it at Harvard Law School and believed in it, left to other parts of government at the federal, state, and local levels to decide what they needed to decide. And he especially respected their commitment to explaining the reasoning in law and logic behind their rulings. He considered the federal judiciary, especially the Supreme Court, the most admirable of the nation's three branches of government for its transparency and for the consistency and fairness it aimed for in a country that, again, his words, was increasingly diverse and pulled by regional and political differences in different directions. He considered it admirable that the court understood that the country needed national law, especially law made by Congress and the court, to keep the country on an even keel by having uniform national rules and norms. It's useful and surprising to note that when Lewis began to cover the court in 1957, the court itself, as we know it, was 22 years old. Here's what I mean by that. The Supreme Court building didn't open until 1935. Until then, the Supreme Court heard oral argument in the basement of the Senate, and the justices worked out of their houses and apartments in Washington, D.C. That year, for the first time in almost a century and a half since the court had been created in 1789, it had a home. And it had a public symbol of its importance, like the Capitol for Congress and the White House for the presidency. If you haven't been to Washington, D.C. to see the court building, it's magnificent, and it is an inspiring place to work, as I had the privilege to do for a few years. The architect, Cass Gilbert, designed a Greco-Roman temple with imposing marble columns and immense bronze doors, and a grand plaza out front that was designed to pull people into the building, up marble steps, through those bronze doors. He intended to make it a monument to justice, a symbol of the court's responsibility for making hard decisions fairly and openly, and he succeeded. By 1935, of course, the court had issued many momentous decisions, and it had been cheered and it had been jeered for generations before that. But it became a nationally recognized institution with power and social capital on a par with the other branches only after that. So for those of you who follow the news closely, including about the Supreme Court today, Anthony Lewis's view of the court must seem almost foreign. No one reporting about the court today from any viewpoint, right, left, or otherwise, writes or talks about the Supreme Court with the same respect that Lewis did. Why not? One reason is the change in the press, first into the media in the 1970s, including TV as well as radio, then into the digital universe with its very different forms by the 2000s, podcasts, video channels, graphic forms, TikTok, and its many different segments or silos. Lewis wrote for the New York Times when the mainstream press was becoming the mainstream media, with the rise of national TV news, the major news weeklies of Time and Newsweek, and the transformation of the Times, the Wall Street Journal, the Los Angeles Times, the Washington Post, from regional publications to national ones. They thought of themselves as, and they functioned as the fourth estate with a responsibility to report and comment on national news and to provide a forum of accountability for the three branches of the federal government. Perhaps the most important way they did that was to provide a common foundation of fact, which framed national choices about politics and policy, even when those choices were intensely divisive. Cable TV developed about two decades later in the 1970s, which tilted the balance between seriousness and entertainment heavily towards the entertainment and exaggeration, especially in opinion journalism. And it led to a splintering of news into liberal and conservative outlets. The internet became a public medium in the 1990s, which fractured the audience for news and opinion even more into those separate bubbles or silos. Today, digital media are at best a carnival of different forms, some of them superb, many of them not so much, but all vying for eyeballs. And at their worst, they are a cesspool of misinformation, disinformation, conspiracy theories, and jarring accusatory opinions. When Lewis reported on the court, the challenge for someone with a comment to make about public affairs was getting access to an outlet, to a platform. That's one reason why Lewis was so influential. The Times was a powerful platform. Today, virtually anyone can have access to a platform from which to launch their ideas, but the challenge is to attract an audience, to get attention. So opinion making and even reporting are much more strident, even about the Supreme Court. But the change of the court itself from Lewis's time until now is just as striking as changes in communications technology and the effects of those changes on the kind of news and opinion. And that's the second part of the story I'll try to tell now about the court and law and politics. One of the best books I've read about the court in recent years is by the legal scholar David Cole. It's called Engines of Liberty: The Power of Citizen Activists to Make Constitutional Law. His book shows that a combination of political and legal advocacy is a basic way for citizens to tell the Supreme Court what they think the Constitution should mean. So he summarizes how citizen-led politics has shaped prominent law and how it should. Here's just a paragraph from his book. To focus on federal judges and courtroom lawyers is to miss much of the story, and probably the most important part. Look behind any significant judicial development and of constitutional law, and you will nearly always find sustained advocacy by multiple groups of citizens, usually over many years and in a wide array of venues, whether it's the NAACP Legal Defense Fund and Civil Rights, the ACLU Women's Rights Project and Gender Equality, or the NRA and the Right to Bear Arms. Underlying almost every important constitutional transformation in the modern era have been the coordinated efforts of politically engaged citizens united by their devotion to a particular constitutional vision. Cole demonstrates that recent court rulings perceived as thunderbolts, as Lewis called them, of newly found law, in fact, are the product of politics turning into law. 2015, the ruling that the Constitution guarantees a right to same-sex marriage. It started in Maine and Vermont and Massachusetts before it got to the US Supreme Court. In 2008, the ruling that it guarantees a right of individuals to own guns for personal use. It started as an amateur's project in legal history in fourth or fifth tier law reviews before that idea caught on and got elite support and eventually found the support of the District of Columbia Circuit and the Supreme Court of the United States. Rulings in the 2000s about the right of due process to enemy combatants in US war against terrorists. These were all products of organized and long-standing citizen campaigns. Another of the best books I've read about the court in recent years is by Joseph Fishkin and William Forbath, called The Anti-Oligarchy Constitution. Both scholars have JDs and teach in law schools, but it's significant that both also have PhDs, Fishkin in politics, Forbath in history. And the joint degrees are significant because they highlight the author's scholarly understanding of law as an expression of politics and economics or political economy, and not as a standalone discipline. And those two frameworks help explain the consequences of three remarkable watershed years for the Supreme Court. The first is 1971, so 54 years ago. The Supreme Court became the Republican court. And here's what I mean by that. Since that year, in every year, a majority of the justices are justices who were nominated by Republican presidents, including each of the three chief justices, each of whom was more conservative than the one before. There's a branch of political science which is called judicial politics, and an outstanding scholar in that field is Professor Lee Epstein of Washington University. She wrote last year that the data depict the current court, led by Chief Justice John Roberts, as extremely partisan polarized, perhaps more so than ever in its history. The polarization is about ideology, conservative and liberal, with complete alignment of nominees of Republican presidents as conservatives on the current court, and of nominees of Democratic presidents as liberals. And what Professor Epstein did was compile with colleagues data about Supreme Court votes in cases where the results and the outcomes were not unanimous. So there was a splitting of votes left and right in every year from 1953 to 2023. She found, not surprisingly, that the most liberal justice was Thurgood Marshall, who was on the court for 24 years from 1967 to 1991, voting for liberal positions 82% of the time. And again, not surprisingly, the most conservative justice in that period was Justice and later Chief Justice William Rehnquist, on the court for 33 years from 1972 to 2005, voting for liberal positions in 17% of decisions he took part in. That difference is an extreme 65%, extreme partisan polarization. But even if you take the difference of the center points for justices nominated by Democrats and Republicans, the gap is significant. 65% vote for liberal positions by Democratic appointed justices and 43 for Republican. So since 1953, a gap has always existed on the court between Republican and Democratic nominees. But surprisingly, the gap in a period of time when the court was perceived as very liberal, the Warren Court, the gap was only about 8%. And why is that? Well, Chief Justice Earl Warren was a Republican who was appointed by a Republican. He was a moderate liberal, and he voted sometimes, especially in some criminal cases, in a more conservative way, and sometimes leading his court in a more liberal way. His closest ally on the court was Justice William Brennan. He was also appointed by a Republican, again, President Eisenhower. And then when Justice Marshall joined the court, were clearly the most liberal justices on the court. So contrary to lots of accounts, the Warren Court was relatively moderate. And most importantly, it was not partisan in the way we now think of. There were significant ideological differences among the justices, but they weren't predictable by party. So let's go back to something I said earlier. The polarization is about ideology, conservative and liberal, with complete alignment of nominees of Republican presidents as conservatives and of nominees of Democratic presidents as liberals. 15 years ago, Justice John Paul Stevens decided to step down from the court. He was nominated by the Republican Gerald Ford, and when he started on the court, he was a moderate conservative, and to use a term that scholars like to use, he drifted. And by the end of this time on the court, 30 some years, he was clearly identified as a liberal. The Democratic President Barack Obama nominated Elena Kagan in 2010 for the court. He expected her to be the liberal that she's turned out to be. That was the first time in American history, only 15 years ago, when the divide on the court, the ideological divide between conservatives and liberals, became a partisan one, predicted by the party of the President of the United States. That shift in the court reinforces the view I've developed that the court is a political institution. That does not mean the justices think of themselves as R's and D's, beholden to their parties and party leaders as, say, members of the current Congress seem to feel they are, particularly these days in the Republican Party. They don't. The justices don't. They work hard to decide each case according to their understanding of law. But the nature of the selection process and approval process for nominees is so political, and it has been for 60 years since President Lyndon Johnson nominated Justice Abe Fortas in 1965, that the feeling of independence that some justices emphasize in their public remarks is almost irrelevant in assessing whether the decisions of the court are political, in the sense that they square with the policies of one party or another. The legal views before justices get nominated often reflect premises about political philosophy, favoring one set of policy preferences or another. Their legal views often align with the political views of the party of the president that nominated them. They usually don't change much on the court. The point is that while the court has made some important liberal decisions since it became the Republican court, many, in fact, its rulings in general, and in particular about major cases, have generally supported policy goals that the Republican Party has long sought. When Republican appointees began to make up a majority of the court 54 years ago, their more conservative votes often determined the outcome of the cases, in particular major ones. The last remarkable year I want to mention is 2020. In that year, Justice Ruth Bader Ginsburg, who had been nominated by the Democrat Bill Clinton, died a month and a half before Election Day in the presidential contest between the Republican President Donald Trump and the Democratic nominee Joseph Biden. She was 87 and had been on the court for 27 years. And when Justice Ginsburg died, President Trump nominated Amy Coney Barrett only 8 days later. They were ready to go. And the Republican-controlled Senate confirmed Justice Barrett only a month later. The Republican court got a 6th justice nominated by Republicans, making up a supermajority of conservatives with 3 liberals in the minority. And what do the conservatives do with their power? They rarely restrain it when there's a result they want to reach, as Anthony Lewis praised the court for often restraining itself when he covered it. They often reach conservative outcomes in radical ways. And here are 3 prominent examples. Abortion. The Dobbs case in 2022, with the majority opinion by Justice Samuel A. Alito, confirmed a crucial insight about the 6th justice majority from Ruth Marcus, a journalist then at the Washington Post. A 6th justice majority is a different animal A six-justice majority, such as the one now firmly in control, is the judicial equivalent of the monarchy's heir and a spare. The pathways to victory are enlarged. A majority of the Republican-appointed justices without the Chief Justice terminated the half-century-old right to abortion. Chief Justice Roberts voted tightly to restrict that right, but without striking it down. And the other five lost his vote, which they would love to have had, and they remade the law. Dobbs stands alone among court rulings over the centuries. It's the first case that revoked a right considered fundamental under the Constitution. The decision showed how utterly the court had changed with the addition of three justices appointed by President Trump. Environmental regulation, also in 2022, the six Republican nominated justices made it much harder for the executive branch to curb a major cause of global warming. They decided that the Clean Air Act of 1970 doesn't give the Environmental Protection Agency the authority to limit carbon dioxide emissions from power plants by shifting the source of power from coal to electricity. The Clean Power Plan, which was what the regulation struck down was called, was designed to help reduce those harmful emissions. The crux of the majority opinion by Chief Justice Roberts was that the case involved, quote, a major question with vast economic and significance requiring clear congressional authorization for the regulation, and the law in question did not provide it. Justice Elena Kagan wrote a strong dissent in which she explained the majority claims it is just following precedent, but that is not so. The court has never even used the term major questions doctrine. That unprecedented action provided a foundation for advancing the anti-regulatory agenda of the political right. And finally, executive power, the 2024 opinion of the court by Chief Justice Roberts again in Trump versus the United States is among the most momentous of the 200 or so opinions he's written in his 20 years as Chief Justice. It explains the immunity from criminal prosecution that a former president now enjoys for conduct alleged to involve official acts in office. As Roberts emphasizes, the indictment of President Trump was unprecedented. No president or former president had ever faced criminal charges, let alone for his conduct in office. It was a novel issue for a 235-year-old court. Again, by 6 votes to 3, the court's supermajority of conservatives ruled that under the exclusive authority of the presidency, a former president is absolutely immune from prosecution after his time in office for actions he took as president, and likely immune for all other actions he took. And the crux of the explanation in the Roberts opinion was that unlike anyone else, the president is a branch of government, and the Constitution vests in him sweeping powers and duties. The opinion defines vast authority for the president under the Constitution, even if no president is ever faced with criminal charges again. And the ruling almost seems to reverse the importance of Congress and the presidency set out in the Constitution, conveyed by the order of its articles establishing each branch, first for Congress, then for the presidency. It's the fullest expression the court has ever made of a maximalist view of presidential power, unchecked by Congress or by the court. In each of these instances, the court's rulings were notably to the right of public opinion. 60% of the country favors a woman's right to choice. About 70% of the country says that business is doing too little to address the problem of climate change. And about 60% says elected officials are doing too little. About 65% say it's too risky for the president to have the kind of expansive power set out in Trump versus the United States. But the point of this story is that the control of the court by Republican nominated justices, with all of the justices in the supermajority nominated by presidents who were against abortion, in favor of deregulation, in favor of expanding executive power, means that the court is now often notably out of step with the majority of the American people in the most prominent cases. Regularly now, by scholars as well as by commentators about the court, it is charged with exercising judicial supremacy, disrespecting laws passed by Congress, and using its supreme power to read into the Constitution vast power for the presidency, while retaining for itself the authority to say when the executive branch oversteps its bounds or not. So if that's the story I have to tell about part two, how does it possibly make sense for me to ask whether the court at this moment should have even more power? And the answer is, as I suggested earlier, but didn't spell out, it's a different kind of power that I'm going to focus on now, which is the trust of the American people. The third part of this story is about legitimacy. Here's how three members of the Supreme Court, Justices Anthony Kennedy, Sandra Day O'Connor, and David Souter, defined legitimacy in 1992. The court's legitimacy depends on making legally principled decisions under circumstances in which their principled character is sufficiently plausible to be accepted by the nation. The court must take care to speak and act in ways that allow people to accept its decisions in the terms the court claims for them, as grounded truly in principle, not as compromises with social and political pressures, having as such no bearing on the principled choices that the court is obliged to make. Not long after that jointly signed opinion, which got a lot of attention, in 2000, in the case of Bush v. Gore, the Supreme Court stopped the counting of election ballots in Florida, and it essentially awarded the presidency to George W. Bush. To many court watchers with that decision, the court proved its partisanship by making that outcome a one-off in American law, by saying explicitly that it was not a precedent for any other court ruling. So when John Roberts became Chief Justice of the United States in 2005, this was on his mind. And in 2007, he gave a remarkable interview to the legal scholar and journalist Jeffrey Rosen, which the Atlantic magazine published. Chief Justice Roberts expressed his concern about, and I quote, the Supreme Court's credibility and legitimacy as an institution. How much Americans trust the justices and the rulings they make. The share of Americans who that year had a great deal of confidence in the court, according to the Gallup polling organization, was only 34%, down from a high of 56% 20 years earlier. And public confidence in the court has gotten notably weaker since that Roberts interview. Last June, the National Opinion Research Center at the University of Chicago reported that only 16% of Americans had a great deal of confidence in the court. And overall, 40% of Americans had hardly any confidence at all. Most of the public lacked confidence in the court's ruling on abortion, voting and election rights, gun policy, and especially presidential power and immunity. About presidential power, only 8% had a great deal of confidence in what the court decided. And 66% of Americans said they had only a little confidence or none at all in the court. One last number, 70% of Americans said justices were more likely to try to shape the law to fit their own ideologies than to decide the law according to the dictates of the law itself. Let me pause to acknowledge that some admirers of the Roberts Court point out that support in public opinion about each of the branches has plummeted, and that however much the court's standing has fallen, it's still more respected than Congress and still more respected than the presidency. In reality, however, opinion about Congress and the presidency has bounced up and down for a long time. And what's different about the data on the court is that it's gone steadily down for a half century, little blips up and down, but it's gone steadily down. And even factoring in the current cultural skepticism about the value of elites, of expertise, of institutions. The decline in the court's standing in opinion and legitimacy is a very significant phenomenon for American democracy. I spoke earlier about the examples of the 22 Supreme Court decisions on abortion and environmental protection, because after that term ended, through public comments, there was a really interesting and important exchange of views about what legitimacy is between two justices. Justice Kagan warned about the threat to the court's legitimacy of those kinds of radical changes in law made by the court. Here's what she said at the end of the term. The thing about judicial decision-making is you can't throw the bums out. We are there for life. And in particular, with respect to our constitutional rulings, there is no way for any other branch of the government to reverse them. But if over time the court loses all connection with the public and public sentiment, that is a dangerous thing for democracy. Legitimacy is elusive and it's ill-defined, but it is indispensable. Little that the court decides is self-implementing. It doesn't have an army. It doesn't have a treasury to enforce its ruling. So it relies on the people's willingness to abide its rulings to sustain its function in American democracy. Legitimacy is commonly yoked to the court by the word of, legitimacy of the court. And that can be misunderstood to mean that the court possesses legitimacy because it's the court. A line in Justice Alito's opinion in the abortion case suggested that he holds that view. He wrote, "We cannot allow our decisions to be affected by any extraneous influences, such as concern about the public's reaction to our work." Justice Alito was, of course, at least partly right. The court needs to apply the Constitution without fear or favor. One of its essential roles is to protect values of liberty and equality from mistreatment of them by the majority in American society. And by definition, when the court needs to take a position that goes against decisions of the majority, it needs not to be cowed by the majority. But the point that Justice Alito made doesn't address Justice Kagan's view, which is that the public's trust in the court is vital, so the trustworthiness of the court is vital too. And it's a reason for the judicial modesty that Justice Kagan values. Justices don't inherit legitimacy when they get on the court. Legitimacy is a form of respect from the people, which the court either fosters or it fritters away by what it decides, and critically by how. Its majority opinions must shape and command public opinion. There's a valuable book on this subject called Law and Legitimacy in the Supreme Court by Richard Fallon. He was a beloved professor of law at Harvard. He was from Maine. He spent many summers near here in Bar Harbor, and he died last week. His decision to replace of with in the title of his book was a small but exquisite example of his brilliance as a thinker, and it underscores what Justice Kagan highlighted. The court earns its legitimacy by the way it behaves. The American people will do what the court says they should only if it warrants their respect. If not, people will flout the court and the rule of law. And that's bad for the court and bad for us as well. And an obvious measure of public opinion is related to legitimacy. An obvious measure of legitimacy is public opinion. The general decline of the people's trust in the court over the past half century is striking. The low point came after the 2022 abortion ruling, when for the first time since polling began, most Americans had an unfavorable rather than a favorable view of the court. To Justice Kagan, that plunge matters again because trust is the basis for compliance in the law. But another measure of legitimacy is protest against the court. In 2023, Chief Justice Roberts gave a wonderful speech about his approach to judging. And one of the questions that he anticipated was, what's the hardest decision you've ever made as a justice? And what he said was, the hardest decision he ever made was to put up barricades and fences around the Supreme Court. He said it was gut-wrenching to arrive at the court in the months after the decision to strike down the right to abortion and see fences and barricades around that monumental building, which had been erected after protests about the decision. They've been taken down since, but that made an impression on him and affected his thinking about legitimacy. The protests were not about the court's authority to interpret the Constitution, but they were about the lack of trust in the decision it made when it took away a 50-year-old fundamental right under the Constitution when 60% of Americans favored the right. It was about the credibility of the court as Roberts had initially defined it in his second year as Chief Justice. If it would be helpful to you to take away one thought from this talk, I want to focus on two decisions that are bookends. One I've already talked about is Trump versus the United States in 2024, when the court talked about addressed the question of immunity for the president and articulated vast powers for the president. Again, as Chief Justice Roberts wrote, unlike anyone else, the president is a branch of government and the Constitution vests in him sweeping powers and duties. The second bookend is a case recently decided, Trump versus Casa. By 6-3, again, along partisan lines, the court severely limited the use of something called nationwide injunctions, which until then allowed a trial judge in a single federal district court the option of imposing against an executive order or other form of law a hold on the law, while the court had the opportunity to address the substantive question presented to the court over time. As a result, the court severely limited a tool of lower federal court judges to block even blatantly unconstitutional policies of the federal government, and it restricted a mechanism of the constitutional system in recent years. I'm using these cases as bookends because each punctuated the end of a court term with an exclamation point, but I'm also doing it for another reason. Trump versus the United States was on what's called the merits docket of the Supreme Court. And those are the cases that you're generally familiar with, fully briefed by the parties, considered an oral argument, decided after substantial deliberation by the court, and explained in written opinions that often at great length explain the legal reasons for the majority's decision and for any dissents. In the 20 years that John Roberts has been chief, the court has averaged around 60 each year. The second case was part of the court's emergency docket. These cases are usually not fully briefed. They're usually not considered an oral argument. They're usually not decided with substantial deliberation, and they're rarely explained in a written opinion by the justices. These decisions are considered procedural, one step in an ongoing legal process and not substantive, but they have enormous consequences. They used to be rare. The administration in office seldom brought them. In the 16 years of the George W. Bush and the Obama administrations, there was a total of 8 emergency docket cases, so half a case every year. In the first Trump administration, there was an enormous change in the norm about these cases, and the Trump administration brought 41. The Biden administration followed that change in norm, bringing 19. And in the first 20 weeks of the second Trump administration, it brought 20, a much higher rate than ever before by the government. Trump v. Casa was only the 4th emergency case in more than half a century where the court had actually given it a hearing and an oral argument. And again, it addressed the legality of the nationwide or universal injunction. What makes the Casa case unusual, though, is that after deciding for several years not to address the nationwide injunction as an issue worthy of court consideration, it took a case that severely limited use of the nationwide injunctions in exactly the kind of case where it seemed essential to have that available to lower court justices. The case rose from a few federal courts against an executive order that Donald Trump, his first day as president in his second term, issued, challenging what's known as birthright citizenship, which the Supreme Court in 1898 called the ancient and fundamental rule of citizenship by birth within the territory. Section 1 of the 14th Amendment to the Constitution and the Bill of Rights says all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. And the court's 1898 ruling means that if you're born in America, unless you're the child of a foreign diplomat, you're an American. The substance of the Casa decision was important about the court's understanding of the balance of power among the three branches, building on that maximalist view of presidential power. The emergency docket was informally called the shadow docket by a conservative legal scholar named William Bode, because what the court does in those cases happens in the shadows. A scholar named Stephen Vladeck published a wonderful book called The Shadow Docket in 2023, where he explains the fast, steep rise in the number of important decisions made on that docket beginning only 8 years ago. In 2021, Justice Alito gave a speech defending the court's use of the emergency docket. And what he said was that the catchy and sinister term shadow docket has been used to portray the court as having been captured by a dangerous cabal that resorts to sneaky and improper methods to get its way. In his book, Professor Vladeck responds to that view by saying that his criticism is exactly in the opposite direction. It's an effort to persuade the court, or at least those who follow it, that it is the justice's shadow docket behavior itself that's damaging the court and contributing to public erosion in its perceived legitimacy. The court's use of the emergency docket is the opposite of the restraint that Anthony Lewis praised the court for engaging in 2 generations ago. It's a very different court in a very different time. It's relevant to our focus this evening because the court's increasing reliance on the emergency docket is an important part of the court's story, and especially important of the story about decline in the court's legitimacy. The Casa case highlights the surge in that number and the significance of those decisions, and the gulf between the court and the lower federal courts, since in the 20 emergency cases brought by the Trump administration, in those 20 weeks, the court had ruled for the administration in whole or in part in 17 of those cases after lower court judges had decided against it, most of the time on grounds that a Trump order was lawless. The judgments were procedural and not about the merits of the case, but they had enormous consequences. Removal of non-citizens to countries not identified in orders for removal, disqualification of transgender service members, firings of probationary federal workers, firing of members of the National Labor Relations Board, firing of more than 1,000 workers at the Department of Education, and dismantling that department. At the National Constitution Center in Philadelphia, in a conversation about the court last month, Professor Vladeck and others speculated why this might be the case. Why is the court backing the Trump administration? And the answer is legitimacy. The speculation of Professor Vladeck and others is that the court is concerned that it lacks the authority to push back on the actions of the Trump administration the way lower federal courts have done. And so it's picking its moment. It's deferring the confrontation by making these so-called procedural decisions and waiting to get to the substantive ones. And another way to make that point is that the court is acting on a belief that the confidence of the American people in the court as an institution is low enough that it shouldn't do what many lower court judges have concluded the law requires and say no to the executive branch. I'll close by returning to the topic of this talk. Does the Supreme Court have too much power or not enough? I told you my answer to both parts. It's exercising power so aggressively that it's depleting the trust of Americans in it, yet it needs to rebuild that trust so it can exercise its power when it needs to check and balance excesses of power of the other two branches. The basic reason I think the Supreme Court now has too much power is that the legislature or Congress has defaulted on its role as a co-equal branch of government to check and balance the executive and the judiciary. And the story I've tried to tell this evening is about two forces that have filled the vacuum that Congress has left as a result of its default: an over-empowered court and an over-empowered executive. I started with Anthony Lewis because his journalism was defined by what he was for, much more than by what he was against. He was for our constitutional system. And as I said at the beginning, I want to say at the end, he believed, as Justice Brandeis did, that the most important public office in the United States is that of citizen. And so he wrote for the New York Times in a form of translation that was meant to empower citizens to understand their court, to criticize it when necessary, to applaud it when it deserved that. And it's been an honor to have you so attentive for such a long time. And the reason that I felt especially honored to be invited to give this lecture is that I agree with Justice Brandeis and I agree with Anthony Lewis that the office that you hold is the most important in this country. And this kind of talk is my opportunity, I hope, to contribute something to that. Thank you very much.
Fine. Thank you, Lynn. That was very interesting and insightful. Now Lincoln City will take questions. I will go around with the microphone. So if you could ask your question into the microphone, because there are listeners on Zoom, and that's the only way they can hear the question. After questions, there's a reception in the back of the library. Any questions?
Please.
What's your opinion on expanding the number on the court?
So you're getting at the next lecture, which is what can we do about this problem? And one of them is to try to change how the makeup of the court is developed. It's much easier to say what the options are than to make them happen. But I have for a long time supported the idea of term limits for the justices. Like a lot of people, I think 18 years is a sensible amount of time. And that happens to break very neatly into division by 9 and 2. And every president would have the opportunity to make 2 appointments in a single term. And I think that would address some of the partisanship that has come about as an accident of history. The 4 appointments that President Richard Nixon got in the 1970s led to the Republican court. The 3 appointments that President Trump made have fortified it, and the numbers are, if you look at the last 20 or so appointments, they're heavily loaded with Republican nominees rather than Democratic, and I think that it would make for a happier and a healthier court if the makeup of the court happened differently.
Maybe in the same vein, the organized pool of candidates on the Republican side, the conservative side, is in fact much more organized.
Yeah.
Now, as it has been over the past maybe 4 decades. And you made the comment a few minutes ago about how some of the most important decisions were actually the product of a couple years of advocacy. And I wonder if you would comment on maybe the concept that some of those decisions leaned liberal, but maybe the conservatives won the war because they didn't focus on individual decisions. They actually built a base of judges and they changed the entire complexion of the court instead of focusing on individual issues.
So embedded in that question is knowledge about the Federalist Society, which was founded in 1982 by 3 law students, but with support from outstanding conservatives, Justice Anthony Scalia, and not yet a justice, but he was a judge then, Judge Robert Bork, both of the DC Circuit, and they have developed a legal program which reflects the political aims that really trace back to the Goldwater era in the Republican Party, clearly to the Reagan era, and in the first term, President Trump essentially outsourced his selection of justice candidates to the Federalist Society, but also to the courts of appeals. And the Democrats don't have anything exactly like that because the liberal wing of the Supreme Court culture is more pluralistic for all kinds of reasons. But there are superb candidates who are both well-educated in the law and conservative, and well-educated in the law and eclectic, and well-educated in the law and liberal. And I think that if by some miracle the opportunity to have a statute that allowed for term limits and each president appointing 2 justices, we would get high-quality candidates, and we would have a more balanced court that I think would end up building legitimacy in a way that Justice Kagan has said is required for the court to function as well as it can.
I have a question about the emergency docket. It seems to me that, as you point out, is one of the most remarkable things that's happened recently in this. And maybe the most important thing about it is you don't get opinions describing what's going on. You just get an outcome essentially, and then probably a dissent complaining about it. I think what you were saying at among the conference you were talking about, that they thought that maybe the court was doing this because it didn't want to look like it's pushing back too much on the, is that what it was?
Yes, I mean, this is a view that has been articulated by William Bode, who's a conservative legal scholar and who coined the phrase the shadow docket 10 years ago, and by Stephen Vladeck, who's a liberal scholar. And it's a view about the social capital of the court, and the premise is that the justices don't want to provoke a constitutional crisis, they don't want to provoke a situation where they say no and the Trump administration says, who cares what you think?
And that's exactly the problem I have with the theory, is if you're talking about the emergency docket, usually it's the court intervening in something to stop the lower courts from doing something. When if they were concerned about legitimacy, they could easily just wait and see how the thing percolates up at that point. So it seems to me that it's just another example of a very, very activist court seeking outcomes and now not even willing to describe them in opinions.
That is also a widely articulated point of view.
Just came up with that.
So I wanted to ask you a question, looking at this from a historical perspective.
Yeah.
In the 1930s, the Supreme Court, which was composed of conservatives appointed by Republicans who dominated the White House for 25 years, frustrated the New Deal. 20 years passed, then Roosevelt and Truman appointed every justice on the Supreme Court. Unsurprisingly, decisions changed. Doesn't that suggest that what we're seeing now is really a reflection of political currents in the country, as opposed to changes in judicial philosophy or otherwise?
So back to 2010. I view it as a watershed in Supreme Court history that for the first time ever, the ideological divide on the court became a partisan divide. So take the Roosevelt nominees to the Supreme Court. Justice Frankfurter was an out there liberal who had taken on all kinds of causes on behalf of liberals while he was for 25 years professor at Harvard Law School. And when he got on the court, he became a conservative. And the differences among the justices in the Roosevelt court and afterwards were deeply ideological, but they weren't partisan. And the difference is that now there's an alignment of ideology and partisanship, and it changes the way the court functions. It also changes the way interest groups frame litigation to go before the court. I completely agree with you that taking the long view in history is illuminating and somehow relieving of anxiety. But in this case, if you take that view, what strikes me as more important is this pivot point in the last 15 years. I could be wrong. You could be right.
We have time for one more question.
This question comes from a veteran who's pretty angry with what's going on, so it's a big bias. I am very concerned about the freedoms that we have enjoyed because the Constitution, as I understand it, and pledged to defend, is no longer legitimate.
So the point you're making is that the Constitution has lost its moral authority?
Yes.
Well, fortunately, the justices don't agree with you. So whatever side they're on, they're trying to make the arguments that have political valences and that have you very concerned about those freedoms. And I share that view in constitutional terms. And that's why the dissents are so vehement and speaking in a voice that goes beyond legalese to try to explain, in their view, the consequences. And to me, the most interesting difference of opinion now is how you think about consequences. In Chief Justice Roberts' opinion in Trump versus the United States, he is thinking about consequences in terms of the need for the executive to have enough independence and authority to solve major social problems. And the dissent, the major dissent by Justice Sonia Sotomayor is saying, no, look what you've enabled, look what's already happening on the ground. And it's a difference between institutional idealism and institutional realism. I take it as a positive sign, and why not try to end on a positive note? That the justices are trying to have this out in constitutional terms. That, if nothing else, should be a constraint on the spillover of what they're doing into political action that could be really regrettable. Thank you very much for all your time.